Taking on the responsibility of acting as an executor is an extremely important role, and one that shouldn't be entered into without considering your personal liability. The first thing you need to establish is that you're actually looking at the final will that the deceased made prior to their death. Failure to do this could cause you to be in a difficult position if there are later beneficiaries who are not included in the will that you've dealt with. To avoid this, it's important that you contact the National Will Registry to ensure that there are no later wills than the one you're holding. Another important point is to place Trustee Act notices in a local and a national newspaper. This allows any creditor 2 months to come forward and make a claim against the estate. This avoids there being unknown bills which come back later when you've already distributed the funds. One of the other things you must consider is all beneficiaries should be checked to ensure that they haven't got a bankruptcy against them. If you pay the money out to the bankrupt and then find out that the money should have been owed to the trustee in bankruptcy, this makes you personally liable to meet the claim were the beneficiary to have already spent the funds. The other thing which is extremely important to consider when you're an executor before you release the money is that you retain the funds from the estate for 6 months from the date that the grant of probate is issued, because there's a law in this country called the Inheritance Provisions for Family and Dependents Act, and that allows certain eligible people to make a claim against an estate. And unfortunately, again, if you've distributed the assets in the estate and then a potential claim is successful, you are the person who is liable to meet that claim. These are all pitfalls which must be avoided, and it's essential that you take advice before acting as an executor. Call us now on 01752 546 448.